Hello friends, welcome to our show Dr. G.K. Goswami IPS. You are welcome to interact with our esteemed guest Shreya Rastogi. I think many of you must be knowing about Anokhi Lal case. In many of my discussions, you must have heard this name of Anokhi Lal. So, Madam Shreya is the architect to the greater extent to bring justice to the person who was awarded death penalty twice. Again I repeat that she is the person who mainly contested in High Court as well as trial court, and then the DNA report was well interpreted, and ultimately the boy who was incarcerated, who was sent to jail at the age of 21, was released. He was acquitted after serving 11 years of his precious period of life. So you can well understand that how wrongful conviction and innocence claim are important. We have just completed 2-day conference in our institute UPSIFS Lucknow on this seminal subject. Personality like Honorable Justice Muralidhar, the ex-Chief Justice of Odisha High Court, and many other dignitaries were here. So today, Madam Shreya, you are most welcome to this show, and we want to discuss few points for the wider benefit of our audience, the participants. So in the beginning itself, I must congratulate the way you are taking the forensic science, the legal perspective into the right perspective of giving the correct justice. Otherwise, what happens that judge generally deliver judgment, but many a times in adversarial system there are chances that person may not get justice, and these are the evident case which you have pondered in the last few years. So may you give salient features of Anokhi Lal so that our the audience may be benefited.
Right. Yes, sir. So Anokhi Lal's case, sir, as you said in your introduction, it is an extraordinary tale, an extraordinarily tragic tale of Anokhi Lal, this poor Adivasi man from Khandwa district in Madhya Pradesh. So the case concerned the rape and death of a minor girl, and of course it was a very brutal and reprehensible act, and it was a case where the investigation was carried out within mere 14 days. And then the charge sheet was filed by the police saying that Anokhi Lal is the culprit. At the time when the charge sheet was filed, a legal aid lawyer is appointed to Anokhi Lal. And the day after that, just the very next day, that legal aid lawyer rescinds his wakalatnama and a new lawyer is appointed, new legal aid lawyer is appointed. Charges are framed, trial begins, trial concludes within 13 days. So the reason I go through this journey of Anokhi Lal's original trial is because it is this manner of extraordinary haste that was shown by the trial court, which was a matter of grave concern for the Honorable Supreme Court in remanding the matter back. At that time in December 2019, this matter was of course argued by Mr. Siddharth Luthra, who is an amicus curiae in the matter before the Supreme Court.
Yes.
And one of the main things that the Supreme Court also notes, apart from the extraordinary haste of doing the trial, was that the DNA report in this case, which was there were two pieces of evidence. This was a case of circumstantial evidence. And DNA, which was the second piece of evidence and was of course very important, that report itself was prepared after the prosecution evidence had closed. The 313 of accused had already been recorded. That is when the report got prepared. It was then submitted to the trial court at the fag end, of the trial. On the day that it was submitted, it was admitted under section 293 of the CRPC, which allows for reports to come into the courtrooms and be admissible as evidence without requiring the government scientific expert to come to court and testify. So this main piece of evidence which was there against Anokhi Lal, which the courts repeatedly relied on, that was something that Anokhi Lal or his lawyers never had an opportunity to confront the witness who had made that report.
The forensic expert, you mean to say.
Correct, yes sir, the forensic expert. And that continued until the second time also, when the matter was sent back in the second trial. Again the experts were not there, the serology and DNA experts were not there. The matter goes back for the third time, and that is when finally, when after a very in-depth cross-examination of both the experts, that is when the same trial court and the same judge in fact recognizes deep errors in the manner in which the DNA examination was done, and Anokhi Lal is finally acquitted. Now the reason I give this picture is because I think Anokhi Lal's case can tell us many stories and holds many lessons.
Takeaway you mean to say?
Yes sir. The main takeaways, one is for our legal aid system itself. I think we need to recognize how broken our legal aid system is, that those who are poor and marginalized are unable to get proper legal representation within the legal aid system, and that is because you're getting a lawyer for the first time on the day that the charges itself are being framed. So the lawyer has no time to prepare for the case whatsoever.
So it is case of hurried justice,
hurried justice, yes sir. And the other thing I think that Anokhi Lal's case really highlights, and something that we need to start rethinking about, something that you yourself have talked a lot about, is the continued relevance of section 293 CRPC or 329 BNSS, which keeps government scientific experts, and now under the BNSS maybe not even government experts, it could even be any other expert who's certified. They will be kept out of the courtrooms.
That means they are exempted.
They will be exempted, sir, and their reports will be relied upon without their testimony.
Yeah,
so I think these are the two main takeaways.
So you mean to say that the right of cross-examination has been curtailed?
Correct, sir, correct. And I would urge us to not think of this just as an issue for the accused rights or for the benefit of the accused. I think oftentimes, you know, in discourse around the criminal legal system, we often create two binaries, accused rights and victims' rights.
Yeah, or your prosecution side, yes.
Prosecution side. But I think, sir, that the need for experts to come to court is actually going to be for the benefit of justice overall.
Correct.
Because that is what will show the strength of the forensic reports, and if there is something which is unreliable or invalid, then that is something that the court will have a chance to perceive better and to keep that out of their determination of the case.
So you rightly mentioned, if we see the earlier section 291, where medical expert, he is called deponent.
Correct.
Right? He is not exactly the prosecution witness.
Correct.
So you are very right to say that the forensic scientist should not take side, whether he comes through prosecution side or sometime defense side also bring them for the defense. So he should be called deponent. Yes, the point is very well taken.
Correct.
He should be like the medical legal expert.
Correct. And he is not, I think you're absolutely right, sir, because then that also creates what many cognitive neuroscientists, when they study the issues of bias and confirmation bias. Today in our country, and this is for centuries now, experts have come into court and testified, government scientific experts have come and testified as prosecution witnesses.
Yes, exactly.
So the mentality that is what we are looking for. We are looking to prosecute, because prosecution also unfortunately isn't fair and neutral. There is very much a drive to get convictions, and that is something that has seeped into our forensic practice as well.
So I generally say, though I am a police officer, but I believe that generally as police we feel, or as prosecution we feel, that when we get conviction we clap, and when we get acquittal we mourn. So I think it is a very right approach, ma'am, that we should stand with the justice. So everybody is there for justice. And having said that, you have done your extensive study in US also. You keep going for Project Innocence to learn through various discourse over there. So what do you suggest that how wrongful conviction, or you can say the SODI investigation, and there are multiple factors for responsible for wrongful conviction. So how do you see, because you are the best person, you are a lawyer on one side, as a trained lawyer, you have studied in New York and everywhere, and now you have taken a task as a mission for rectifying the forensic errors, right? So how do you see, and what kind of advice you provide to the institute like us, because we are giving training, we are giving education to the young generation experts. So what type of pedagogy you suggest for us to ponder here?
Sir, so I think in terms of ways in which we can prevent wrongful convictions and the role that institutions like the UPSIFS can play in that, I think there's so much ground to cover here. Firstly, I would say that back on the point of legal representation, I think we need serious reform, law reform, around the way in which an accused person is able to access lawyers and what rights do they have in being able to access lawyers. Implementation, constitutionally it has been established for many decades now, since Hussaina Khatun and henceforth, that every person has a right to legal aid. And every person, of course, in our constitution itself, you have a right to be appointed by a counsel of your own choice. If you cannot afford a lawyer, then a lawyer will be provided to you.
By the state?
By the state, sir. But today, the stark reality is that most defendants will, whether represented by legal aid lawyers or by private lawyers, they will get access and directly speak to their lawyer at the first time long after the investigation is completed. Charge sheet has been filed. So the entire case has been made against you. It has been filed in court, and that is the first time that most people get to access private or legal aid lawyer. So firstly, I think we need to raise the standard, the quality of legal representation, and that is not something which I think oftentimes people think that private वकील है तो अच्छा वकील होगा, पर वो बात नहीं होती है सर. प्राइवेट हो या लीगल एड हो, वकालत दोनों साइड पे शायद ना हो ठीक से. So
even the prosecutor have deficiency in knowledge.
Exactly,
very
sir.
right.
So that is one thing. The second thing I would say is that I think we need to there have been many judgments, right, from Shasikala's judgment to Manu Vashisht's judgment to Ponnuswamy judgment, talking about the right of the defense to be able to access materials which are A, exculpatory in nature, B, that even the prosecution does not want to rely on.
So you mean to say like Brady violations?
Exactly, sir. Yeah, that the kind of discovery norms that we have, as it's called in the US, that to be able to access all information that the investigating authorities came across as part of the investigation, whether it's inculpatory, exculpatory or whatever, that right needs to be secured. Today, under 207 of CRPC, you're given the charge sheet, you're given the police statements as part of that. You're given probably if the reports, forensic reports are ready or the medical examination report, etc. But a lot of that is controlled narrative. It is only the narrative that the police has submitted to the court. It may not include everything that they did as part of the investigation, which was exculpatory in nature, that there may be documentation for. They may not disclose that. And that then really curtails the right of the defense to be able to meaningfully challenge the case against them.
Yeah. You rightly mentioned, and I think I want to add two angles here. Like very much in Anokhi Lal case itself, on 18th December 2019, with the case where the matter was referred back for the de novo trial, in that judgment itself, they have given certain guidelines for how the legal aid shall be allotted. So, but I don't know whether those guidelines are properly being addressed or properly being implemented. But here I want to tell something and get your view that in the wake of section 176(3), now in BNSS, now forensic evidence collection becomes mandatory in heinous crimes. So I do believe that now forensic aid should be integral part of legal aid, because legal person cannot justify until unless we support through the legal forensic expert. So I must say, if I say mathematical construct, that now it is the time for legal aid plus forensic aid.
Correct. If
we want to extend the legal support to the accused. So what is your take on this point?
Absolutely, sir. I couldn't agree more, and I think that it is important that we redefine what is legal function or what is the defense function within the courtroom. The reason I'm using this language is because, like for instance, to borrow what has been written in the American context, they look at the defense team as a team which will involve a fact investigator who will also go and do their own investigation, go do site visits. How many defense lawyers are able to take out the time to go and visit actually the site? So much changes on the facts and how things actually happen on ground. So for defense teams to be enabled with a fact investigator, for them to be enabled, of course sir, the fact that they should be able to access forensic experts, because वकीलों को ये सारी चीज़ें knowledge नहीं होती हैं, and they will need their own forensic experts to be able to access, and if they so wish, then to call them as defense experts into the courtroom as part of the defense evidence. And thirdly, sir, I think we need to redefine defense function to include even the components of mitigation investigators, because for so long we think about lawyering and also what happens in the trial court. So much of it is fixated on the conviction stage. We don't think enough about the sentencing stage. Even the law on sentencing in India really needs to improve, because in sentencing, the facts which will become important about a person's moral culpability, about the person's life history, वो क्या background से हैं, उनको मतलब before the crime occurred, what was their life like? After the crime occurred, what has their behavior been in prison? All of those are things that need to be looked into, and those are again things that we believe that lawyers are not capable of gathering and analyzing. There are so many kind of social workers, psychologists, sociologists who can provide very useful and important lenses to the angle of sentencing, because sentencing is not just a legal exercise, it's a socio-legal exercise. So we need then the help of many social science professionals, and that also should be incorporated within the defense function.
Very rightly said. One another issue which I want to flag and we are trying to address in this institute, I want your opinion that, as you rightly mentioned, that the legal experts are not sufficiently trained in forensic science and other corroborative evidence sometime. So we have started one concept called law with labs, and we are trying to provide the laboratory exposure to the legal expert. So how do you feel that the content of the forensic science in evidence study or the subject of evidence is insufficient in our legal study? So don't you think that it is the right time that the legal expert, he may be a judge or maybe a prosecutor, maybe a defense lawyer, they should be given a proper training on how to explain, how to explore, how to interpret, how they should must understand the underlying data.
Correct.
So
Absolutely.
These are the very important points. So what is your opinion?
I completely agree with you, sir, and the fact that we are creating more opportunities for not just training. I think we are educating lawyers and legal professionals and judges, because the need for that training comes when there is some prior knowledge that they already have. But there are so many legal professionals who lack even the knowledge, the basic skill sets
that's
to
very
understand.
So the training itself is not going to...
It is not even to talk about training. Training would presuppose that they have some knowledge. There are many people who have no knowledge, sir. There are so many myths that they will continue to have about different forensic disciplines. So I think it's so important that you have created this concept of law with labs, because we need to definitely create more opportunities. And I think the manner in which we should approach it is, we have to take a wider lens of these things, because oftentimes trainings around forensic science only get limited to informing people about that this is the technique that analyst may follow in the lab. But I think what we need to, the approach has to be wider. It has to involve a lot of discussion on evidence law, a lot of discussion on what are the ground rules of evidence law in our country. For instance, we know that oral evidence has supremacy in our evidentiary framework. Now, when you compare that to the way in which expert evidence is led in India, there are obviously certain contradictions that start to emerge. So we need to think a lot about that. We need to get people to think about what is the standard of admissibility and weight for expert evidence. We've talked about admissibility and weight maybe in other contexts, but for expert evidence, we have not really, there are no clear legal standards. The fact that we need standards for who is an expert and how do you define an expert, what is science, the concepts of validity and reliability, those are lacking from the way in which we've been looking at expert evidence law. So these are things that I think we need to incorporate apart from getting people to becoming familiar with the basic concepts, because you are not looking to make lawyers and legal professionals into forensic scientists.
Exactly.
They just need to have some basic knowledge so that they know enough to reach out to a forensic scientist.
Very true. So you have rightly flagged one very important issue. I think the most pertinent, the definition of expert is very much required, neither in section 45 of the Indian Evidence Act of 1872 nor in the latest section 39 of the Bharatiya Saksh Adhiniyam 2023. So I believe, as you rightly mentioned, that this is the utmost important amendment required in BNSS or in Bharatiya Saksh Adhiniyam, so that we should have a proper definition of expert or Visheshagya. And having said that, we are actually announcing very soon about the Innocence Clinic. Our Honorable CM of Uttar Pradesh is visiting on 19th of March for an international conference, and that day we are planning to have this launching of Innocence Clinic. So you have visited US and must be aware very well, I know. So what is your take? What kind of precaution we should take and what type of model we should adopt for Innocence Clinic in India?
So I mean, it's firstly, let me congratulate you for the vision that you have of starting something like the Innocence Clinic here at UPSIFS, because it's and having spent 2 days here now, it's such a great concept to have something like that in an institution which has both law students and forensic science students, because I think they can really complement each other. And I'm only hopeful for the next generation of legal and forensic professionals that come out of this institution. I would say that as part of the clinic, sir, it is important that we figure out that in terms of our approach, the approach has to be one that is not only looking at cases where forensic intervention can happen. What I mean by that is, like for instance, in the US, as you know, sir, the Innocence Project very much began with the idea of looking at those cases where there may be some biological evidence which through DNA profiling could prove the innocence of the individual. Now, there are many cases in India. I mean, we are still, while we talk about DNA profiling, vast majority of the cases in India, the criminal cases in India, don't have any kind of DNA profiling, don't even have proper kind of evidence collection.
Access of forensic evidence.
Access of forensic evidence, sir. So therefore, I think we'll have to think of our Innocence Clinic in such a way that it is not only dependent on presence of forensic evidence which could be further examined or forensic samples which could be further examined. Of course, that can be one part of it and it should be one part of it, but the other side of it would require us to look at cases where we see the potential for torture having been carried out, and confessions being extracted through torture, recovery, yeah, exactly sir, recoveries through coerced confessions, another big problem, and that is going to be one very big aspect I think that should form a part of our innocence work. On the forensic side, I would suggest that we should also keep in mind that we are able to follow validated protocols when we send samples for reanalysis, because we will have the problem we'll have in India is that we don't have enough independent labs where samples can go for analysis, since most of them are government labs where this analysis happens. So it will be somewhat tricky for us to figure out in cases जहाँ पे forensic analysis नहीं हुआ है वो कैसे करवाएंगे, और जहाँ पे हुआ है अगर उसका reanalysis करवाना है तो वो कैसे होगा.
These are the real challenges.
Correct sir, correct. So these would be some directions for us to think about.
So thank you very much for having this association, and I request you to bless our institute on the regular basis, because you are one of the very leading professional in this field, and you are very young, but your achievements are stellar, and I have seen your growth last almost a decade, and I am very happy that the way you are serving the nation in the interest of justice is really phenomenal, and I am really grateful that you have spared time with our channel, and our participants, our friends are highly benefited with your vast experience. Thank you very much, ma'am, once again.
Thank you so much.
Thank you.
Thank you.
Thank you, friends. So you have seen a very live discussion today on various aspects. Probably many of you may not be knowing what is wrongful conviction and how they should be addressed. Generally, we believe that justice system is perfect. Of course, we expect that, but as the human beings are involved in delivering justice, so mistakes are bound to commit, but we have to minimize those mistakes. So be happy, enjoy, and thank you very much for being with us. Bye. Good day.